Hey guys, can you hear me? Hello, hello. I'm assuming you can, but until then. Okay, so I hope you all had a good week. I've been traveling quite a bit. Right now I'm in Michigan City, Indiana. So getting some work done, but also handling some personal affairs that I have to. Hi, Vols 85 and Melanie Frost. Good to see you guys. There was something I was going to share, and honestly, I have to find it in my email. It was from NOSCR, and they were, I believe, and they were discussing how they have this whole kind of a task force on AI and how it can be used to speed up some of those administrative tasks that are really slow, I guess, when done by humans. Administrative tasks, meaning not the ones that are deciding if someone's disabled or not. But I wonder if I can find it in here. If I do, I will post it. But I think that's kind of interesting, and I really want to see things sped up. I just had a text from a client who, hi Dimple, who is on day 298 since we filed, and he remains on initial. So it is long. You know, so sometimes, I mean, there's one little caveat here, guys. If it's going long and you're not using that time to really make your case stronger than it might have been when you applied, you're really wasting what could be. Because if you get a denial after that long wait because you didn't, you're probably going to be really cranky, right? So there's so many things you should be doing on initial, aside from going to any kind of CE exam that they request for you. I've had people ask, well, do I have to go because I did this once and it didn't do anything for me? I'm like, well, if you don't go, the only reason they're ordering it is because they can't clinch you with an award thus far, and that's to see if maybe they can after. So if you don't go, you're generally going to see a denial. I think that's by and large generally what's going to happen. Doesn't mean there aren't exceptions, but I don't even know if I've ever seen one of the exceptions. So, oh, Justin, good to see you. You have a hearing date for August. Excellent. Use it. Hope you have some good advice, Justin, on maybe what might be weak in there, if anything, that you can then go to a specialist for or get an updated diagnostic if those are kind of not so current. Updated ones are good, guys, particularly if they're going to show that something's worsened from what you had before. Maybe what you had before on recon, you know, was able to be kind of denounced as not as severe as what you feel it is, but a new diagnostic sometimes show that it is deteriorated. And now that helps a judge have a reason to, you know, in theory, to make a different decision than the people down below. Okay. Vols 85 says, so watching your videos have helped so much. Oh, I'm so glad. With my appeal and reconsideration appeal. So I did get chosen for the federal quality review after step 3 and was approved yesterday. Okay, awesome. Yeah, quality reviews, I do find them to usually be a good sign because someone usually thought you were disabled up there. And so someone else is saying, oh, you know, random audit, we got to check these. But you already have someone who's ostensibly trained in deciding whether someone meets the criteria of disability at that level, all those check boxes. So I think that the chance of getting overturned on quality review are far less than what people fear. Not that it doesn't happen. I think someone had commented on one of them that he or she did in fact get a denial on quality review, you know, a flip. In which case then you appeal, as would be the norm. It's just unfortunate. So Vols goes on to say, so I was one of the 50% approved appeals chosen for. Do you think it's 50%? You think they audit 50% of awarded, you know, ones where the adjudicator said, I think this person needs to be awarded? I don't know if it's that high. I don't think it's that high, Vols. I think it's much lower. I thought way back. I mean, I remember when this came up like 15 years ago, it was like, I thought I'd read it was 13%. Now I think I see that it's less, but I'm not sure. I'd have to see something writing before I'm convinced of anything. Melanie, hi there. Melanie says that her case was remanded in federal court after 4 years. Do you think the money for retro and SSA back pay will be there for those who win their? Yeah, the money isn't going to go anywhere. Or I should say, it might be going places where it's wasted. We know that's a fact. However, everyone can have their opinion. They just jack taxes when they lose money in these funds, right? So their way of solving it, like in 2015, what did they do? They took away a big chunk of spousal benefits from retirement. That's how they save a little money. They do different things like that. They might, some people want them to up the cap on the income tax, the income upon which Social Security taxes can be levied. That might be the most popular if you have to do something where you're taking from others, again, because of the mismanagement of the funds, perhaps. And I say mismanagement because that's what we're always kind of thinking, although it could also be just the mere numbers. We have less birthing people that then go to work and pay the Social Security taxes that then go into the fund to support the baby boomers and all of us that are getting older to pay our benefits. So, but I cannot foresee a decision where it's like, oh, we're just not going to pay. No, they're just gonna jack people, workers or whatever, to make it happen. I don't even think they would reduce the amount. People say they're gonna cut your Social Security by 33%. It's a big fat lie. There's no evidence to suggest that, and that would just be a political. Anyone who did that would probably not survive. Anyone up there that did that. So yeah, I wouldn't worry. What you have to think about, Melanie, is if I win. Because you have a federal court remand, so you're going back to the judge, and does he award you? If so, remember, he makes a whole new decision, he or she. So does he award you? And does it go back to your original alleged onset date, or does he find it something later? Or does he deny you? I mean, he doesn't have to award you just because you got remanded by federal district court. So he will, if he decides that, yes, indeed, now I'm seeing the light and you were disabled, and the evidence proved it way back, then the money, of course, will be there. I wouldn't worry about that. Who they have to stick it to keep the money there, to be paid out is a whole different question. And Melanie also asked, will I have to wait a long time for my hearing? I think I will have to wait. It is kind of getting longer. Not terrible as we've seen it, like, in the mid teens to maybe 2019, we had like 2-year waits once you applied for ALJ or were in line for the ALJ. Then they came greatly down around 2019 to like 4 or 5 months I was seeing. Now they're starting to tick up the last year or so. But remanded cases take a bigger priority than the other cases. So that should, they're on that list of which ones to be done first. Hi, Trish. Nice to see you. The Flyer. Nice to see you, Flyer. Would a CDR be as intense as a first application for SSDI? I went all the way to the ALJ. Thanks. I don't think it's as intense. However, it's going to feel the same in a way, because if you get the longer form, so that's like basically like the 3368, you got to put all the doctors that you've seen and all that. There's going to be some paperwork. You might go to a CE exam. If you get that short form, you probably won't even have a CDR in essence, because they'll see, it really depends on your diary. Are you expected to improve or an expected to not improve, but I don't think they're as intense because they've already known that you were disabled. So it's almost like you just need to show a continuing of what you already know you had versus reproving that whole newness again. That's not what you have to do. You're really just tasked with showing that it's as disabling as it was, or if it improved a little bit, because sometimes we improve when we don't have the stress of a case on it, that it didn't improve enough that I could go back to work at any job full-time, any job. Okay. Heather, how are you? And by the way, thanks guys for being here on this Friday. This was like, I couldn't do it Wednesday because I'm traveling, and I knew Thursday wasn't going to work well because I was traveling. And I thought Friday I could sneak it in. So make a Wednesday into a Friday. So thanks for showing up. I know that was kind of unexpected, maybe. So Heather says, I'm going to an appeals hearing next month. I'm sending an updated 3373. That's the function report, guys. Please advise how to answer number 5 and 6 since I work very part-time. I can't tell you how to answer it because I don't know your file, Heather. But if you work part-time, number 5, that shouldn't matter. You're answering questions as to how your impairments prevent you from working. Doesn't mean working, like if you can't stay, let's say you're working part-time, you have 3-hour shifts. You could be that answer number 5. If you have, this is just a, for example, musculoskeletal problems, a back problem. You might be saying, I am unable to work, be on my feet more than short periods of time. I wouldn't give minutes or anything. They're going to see that you have part-time work, which you're probably going to, if you haven't already, you should be describing, that work in maybe an updated work history report, unless you already included it in yours and did it in a thorough way. Keep in mind that there's a new work history report. The 3369 is not what it was before. So if you filed your work history report before June of 2024, I think it was, you will find that there's a more robust questionnaire for each job. And I think that can be really helpful if you know how to recognize those questions and what they mean and answer them accurately and responsively. It can be helpful to you. Number 6, yeah, you're going to say, on the days I work at my part-time job, I go to work. That's going to be, you can have that somewhere in there. And remember, with number 6, I always suggest you really want to point out the things that you don't do well or normally or take longer, or if you have to take naps during the day or a nap during the day. Let's say you go to work for 3 hours at 10 and you get home at 1 and you have to go to the recliner. I would definitely be putting that in. But again, I can't obviously speak specifically to you, Heather, because I don't know your case. And it's very, very, very fact specific. Michael, nice to see you. I have my CE physical exam scheduled for May 1st. Generally speaking, does the decision on my initial application come soon after the CE? Also, should I even mention my veteran status at the CE? First question. Does the decision on my initial application come soon after the CE? I always found that generally that was the case, but not always, particularly with, the last few years with the hiring freezes and such. Sometimes you could have the CE, the consultative examiner might not get his report in for a number of weeks. It used to be, I always used to see them within days, and I still often do. So, I still think they kind of tend to come. Usually the CE exam, in my opinion, is ordered after they have what they consider to be all or most of the records. So that's the only reason why they know they need a CE, because the records didn't quite do the job for you that you'd hoped. So, and so usually but things can vary, like I said, and the medical expert that all of the medical records end up going to, once the adjudicator feels he's gotten everything he reasonably can, including the consultative examination report, then shifts it over to the medical expert to decide what is the RFC, what are the impairments, and make, are they severe, and all those little categorizations that need to be done. If that guy goes on vacation, could be another few weeks after that. So to me, it is usually the next step, but how fast that step is going to take can vary. I usually see it within weeks, but every case is different, like I said. Melanie, you're welcome. Michelle M. 58 years old with severe S scoliosis, 84 thoracic, 75 lumbar, tons of back issues. Ortho says no surgery planned, recommend pursuing and exhausting conservative care such as PT and injections. Understandable. I'm just looking for part 2 if she has it. Part 2, I believe. This is part 2 for Michelle. Saw physical therapy, and she said, can't do much for me since I can't lay flat due to hump in my back. I'm sorry about that. I've seen that. I even have some of that in my family. Won't let me lay flat. My PCP is trying new meds, prescription for a walker. I don't know if you have a question here, Michelle, but post it if you do, and I will try to pop back up to it. But I do wish you the best of luck. Hopefully you have, representation. If you don't, feel free to ask us to look at it, and, we'll get back to you pretty much right away. Galama Girl, good to see you again. They already know we have to wait years to get to the point of federal court, so why not just decide the case? I don't understand the whole remand thing. Federal court doesn't have the jurisdiction to decide your case. They have the jurisdiction to decide that the administration missed something, and they have to go back and do it. If the federal court, there's once in a blue, I think they can have it. I don't know if they ever do a complete reversal, they definitely largely remand and send it back to the body that has the obligation to make a decision following the certain laws. Federal district court is not the Social Security Administration. It's not trying to decide your case. It has to decide whether the law has been met in terms of the obligations of the SSA in its evaluation. So that's why you're not having some federal judge, deciding whether you're disabled or not and making that decision, generally speaking. They don't skip steps because someone has waited so long, but they do make remands have more priority in getting hurt again. So that's where you get the benefit that someone who hasn't gone to federal court does not get. Okay. I know the wait is really long. And there's tons of federal court remands that are before you that will come before you also, generally. Marie, nice to see you. Oh, Michael Kingsley, I will jump up to you. I see that I missed you because I went from Heather, right? Oh, no, I did answer you. Sorry, Michael. Marie, good to see you, Marie. Oops. I had gotten a hold of my congressman because holdup of workman's comp back pay and 1099. They got all this fixed in except restoring my monthly. Does this take longer? I don't do workers' comp, so I can't really speak to your workers' comp. So that really wouldn't be something I can respond to. Although if you're saying restoring my monthly Social Security checks because they were held up because of the workers' comp issue, because they had to check, they probably had to get your workers' comp straightened out so they can do the 80% rule with your SS and see if that applies to you, the offset. You did get the workers' comp straightened out, you said. I would get on them about now that they have the workers' comp all straightened out, yes, the SSA should be doing the math on whether or not you have any kind of holdup of your Social Security. And if it's sitting there and you don't know where it is and what's going on, I'd give it a little time. But yeah, I would reach back to the congressman probably and say, the Social Security has not acted on this stuff now. Can you poke them and get someone to now finish the steps of, evaluating the, what do you call it? The 80% rule or whatever. You don't have to give them the specifics, but just say SSA has not yet taken steps now that the workers' comp is resolved, and my still don't have my Social Security benefits. I would. He's already in on it, right? Okay, Michelle M., who discussed you're 58, right, Michelle, and you have all those back problems, including a hump in your back that makes it difficult to lie down and all sorts of back pain. She's not sure what to do next. I made an appointment with a neurologist. I have been to see a rheumatologist. I'm under care for breast cancer. I'm winning. Good. I'm so glad. I'm so sorry that you're going through all that. Just don't know when I'm supposed to apply for disability. Oh, you haven't even applied yet. You haven't applied yet, Michelle. When did you stop working? It's all about kind of when you stop working, mostly. Give me a buzz, Michelle, or email. Mention that we spoke here, and I'll give you a call and we can just go over everything. All right, Maria. Yeah, so I would call the congressman about restoring your monthly SS, and if they could just put he's not making the decision of what the math is. He's just lighting a match under them to get them to do the step that their particular area is supposed to do. Rolando, nice to see you. I don't think I've seen you here before. Very nice. Since approval for SSDI for neck surgery, been treating with pain management. Will this be enough when it comes time for a CDR? Also have been diagnosed with heart failure since approval. Since approval for SSDI for neck surgery, been treating with pain management. Potentially, it's like you're continuing, what you're doing. Hard to say not knowing all, your entire case. But pain management certainly indicates that you continue to have pain to the extent that you need treatment outside of popping a Tylenol here and there. So I assume you had neck surgery. Do you follow up with your surgeon? Do they do periodic, even if it's just like annual MRIs to see where the hardware is, if there's hardware in there, that everything's good? I mean, it doesn't hurt to complain to your surgeon if something is still hurting. And can we just check it out and make sure nothing is, grossly wrong, aside from the fact that you had to have surgery. That's maybe what I would do if you're worried that pain management might not be enough. Just me. Good afternoon yourself. GC24, thank you. That is very kind. I appreciate. JR, over 5 years, chronic gout, same GP doc, general practitioner. Only see the doc once or twice a year, no insurance. Have all medical required chronic evidence. Does infrequency of doc visits play a large SSDI factor for approval? How large depends, but yes, it can play a factor. You say you have no insurance. Well, have you applied for state assistance with insurance? That is something that I think everyone needs to do. If they really are legitimately not able to secure it through work, which obviously if you're not working, you can't. If a spouse can't get a job that provides it through work, that would give it to you. And if you're otherwise don't have, a huge savings account or 401k from which you could draw to buy yourself some health insurance, it is a factor. And I would say, JR, very infrequently, I think, unless you're super young, which is going to be a very big uphill battle, do we have just one medical problem. That you're talking about chronic gout, which I know can be. I had a case like that not long ago. There would be flares where the person would be unable to stand on their feet at all for weeks at a time, and it would happen multiple times a year. The other times could stand on their feet, but what kind of job is going to, in a competitive work environment without huge accommodation or FMLA or something, is going to let you not work 3 weeks every 4 months? It's just not part of the competitive work environment. But do you have other, so much will depend on your age too. What, are you over 50, under 50? And do you have other medical problems? And I know you don't have insurance. You have got to go get insurance unless you have, you have to be a squeaky wheel with that. And states can differ, but don't, if you get denied for state Medicaid, appeal it, and get your doctor on board. Sounds like he would be on board if he's treating you for it. Yeah, twice a year, just saying I have gout. That doesn't even say how many, that's not even proof of how often you have a flare. I mean, my husband had gout when he was 22 or something like that, or 18, or he was in the military, I think. And I don't know that he had it since. So, you really have to, do you talk to him about how frequently it is? Do you message your doctor even when you don't have an appointment to let him know I had another flare? It lasted from this day to this day, and I had to stay on the couch. All sorts of things to communicate with your doctor when you don't have a visit. Doctor might not care, might not do anything about it, but at least you'll have proof in that record when the records get ordered that you've been complaining all this time. You could even say, Doc, I can't afford an appointment right now. I don't have insurance, but when I do get my appointment coming up 4 months from now, can we please talk about some better remedies? Because I'm wiped off my feet more than I'm on my feet because of this gout, or whatever the case may be. DSMS. I was denied spousal SSA benefits because they said I received more in benefits than she was receiving when she passed. I feel cheated. Is this true? Yeah, you're not cheated. We get spousal benefits when we don't have our own, or if our own are so small that at least we can get up to what our spouse would have given us. We don't get both. So I know that's a huge misconception. It's always been that you don't get both. And you're going to get the bigger, you pick. Obviously, you're going to pick the bigger, right? But it's not a cheat. Imagine if you had like 5 ex-spouses and got to stack them all. Woo! We'd all be living high in the hog, and there would be no money in that Social Security fund. Heather W. Okay, my phone number is, I'll type it in here, 201-317-0610. And the email, I'll say you could just do contact@joydisability.com. And I'm sitting at a weird desk, guys, so if I look a little different, I got my background, but on this like wicker stool. in this little room in this little place. Contact@joydisability.com. And if you go to the website, guys, joydisability.com, and look in the upper left-hand corner, for those that need a review, we'll tell you if we can't take you, or we'll tell you if there might be an opening where we could take you. So you'll know one way or the other with that pretty fast. I mean, I am traveling this week, so things have been a little slower, but first we look to see if we have any openings in that area, and then often we do. So then I usually just hop right on the horn and give you a call. And sometimes we play a little phone tag, but DSMS. I thought everything had to be private. Not sure what you're talking about. What's private? Heather W. Heather W. Yeah, DSMS. I'm not private. I'm on here in public. If you're talking about me giving the phone number, Heather, I guess it was Heather that asked for it, and the email. That's fine. It's on the website. It's not. It's business, guys. George, I need to know, are we getting a stimulus check? Let's hope not. That would be a little silly, right? Just me. I recently had my brain MRI with and without contrast, just waiting for the radiologist report. I hope it turns out good for you, you know, not for your case, for you. Brain MRIs. Okay. I am not seeing any questions. Sometimes they come up a little late for me, though. But anyway, pop them in there if you have them, guys, and I will get to it. Going back to CDRs and whether your information is sufficient, like, you know, like Rolando said, going to pain management. Pain management can be a good one, but it kind of depends also. I do think follow-ups with the surgeons are important, particularly if you're going to be kind of clear about what still hurts and what the limitations are. And, you know, they're almost always going to say, he's improved, you know, but not always. And even if you have improved, because that's what surgery was intended to do, there can still be significant limitations. You just feel better much of the time. Doesn't mean you can work full time, right? So if you look at what you did for initial and recon or wherever it was when you were awarded, consider following up with all those areas. And then if you have new impairments, but of course, follow for those too. You know, usually you start with your PCP and they determine a new problem. And then sometimes they don't refer you to specialists when maybe I wish they would have. But always think about that. Is there a specialist that treats that kind of thing? And maybe it's time to go to one, you know, for a new issue. Like an endocrinologist for, if diabetes, particularly if it's controlled, it's not really terribly disabling. But if it was uncontrolled, for instance, maybe you would be seeing an endocrinologist. Someone, you know, aside from the primary care who's not getting it under control. That's possible. Chandra Maloney. Hi, Chandra. I hope I'm saying that right. Do they take child support? Does who take child support? JR, you're 51, live in Colorado. The reasons for infrequent doctor visits is the longevity of gout. Longevity of gout. Meaning you've had it for decades, or you mean each stint lasts for a month? You know, is it the duration of a flare you're talking about with longevity, or the fact that you've had it for many, many years? Have all tests, x-rays, high dose 600 milligram aloe in 3 or 4 attacks every 3 to 4 months, bad, not walking. That's what you got to get the proof of, right? So if you're having attacks when you're not at the doctor's office, you need to report them to the doctor. And I wonder, is there, you tell me, or just think about it, is there any kind of acute treatment that one does in your situation for a flare, as opposed to the preventive treatments you do to keep them at bay as much as you can? You know, is there, like, when there's a flare, you get this extra thing going on, or an injection of this or this pill or whatever to help get rid of the flare, as opposed to the preventive? Kind of like a migraine might have a an abortive medication that you take only when the migraine has started? If so, amongst other things, might that be something that gets filled every time you have a flare? But nonetheless, you should be, in my opinion, for evidence building purposes, sending your doctor, if there's a portal, that's great. Do a message through the portal and just say, I'm going through a terrible flare right now, doctor. And every time you do it. So, and then because you're saying it's 3 to 4 attacks every 3 to 4 months, keep a journal, and you can actually upload the journal pages, that show when you had the flares and how long they lasted, and if they were bed riding or not. Because then those things, once they're sent to your doctor's record, they become part of your medical record. They're not a diagnosis or anything, but it'll show a year from now that you were complaining a year ago. This isn't something you just start, inflating at hearing. This is like, you have the backup that's been, you've been talking to your doctor about. That is really important, I think. The in-between, what happens in between when we're not at the doctor's office? All those flares that you just kind of suffer through, that you really want them to be on the record, Melanie asks, Melanie Frost, is new evidence allowed in federal remand hearing? Oh, yeah. So when you get remanded back, all the time period since your last ALJ hearing, that's all the new evidence you're going to bring in. And of course, anything that you forgot beforehand, if anything was missing, you're going to get that in. So this is where you really have an opportunity to get in a lot more evidence. Now, if your DLI, date last insured, is in the past, you're still going to have to deal with that, as they have to find enough evidence before the DLI. And usually they, unless you've been working part-time under SGA while your case has been pending to extend your DLI indefinitely, you're going to have to deal with a DLI that's remote, and it makes for a more difficult case. But definitely, and look through all that evidence from the first hearing as well, and see if anything was missing, because now the judge has to let anything in, because now you're heading to hearing again. So anything is fair game to add to it. Okay, that is probably the most significant, important thing you have to be doing, because now you're heading back to hearing, and now you can submit more evidence. You couldn't submit it to federal district court, the appeals council. It was only about stuff that occurred, before the date of the decision. But now it's fair game. So you got lots of work to do, Melanie. All right, Lulu, good to see you. I went for mental evaluation. It took 15 minutes, but they told me it was favorable. Now I also went for my physical. It took like 25 minutes. Still had to go for x-rays. What could happen? I'm 61. Well, as you know, what could happen could go either way. But, and I don't know your case. Obviously, you're in a good age group. So if you meet the rules that are required for a grid of your age, they will award you. Yeah. So I don't know your case though, but it sounds like they told you your mental evaluation was favorable. I don't really know. Were they saying we're going to say that you're mentally unable to work at all? That's a real high bar. You don't even need that high of a bar. And I hope it doesn't look, incredible. Or are they just saying that, yeah, we could see you got depression or anxiety or whatever, and that you're distracted, maybe your concentration's off and you couldn't really follow directions during the mental status exam. Really depends on the specifics of your case, Lulu. GC, does a claimant's RFC resets on a new claim by the DDS? A new claim will have a whole new RFC, yes. Like the ALJ states, reduced light work on the denial, but on the refile, the DDS makes the RFC heavy. Is this common? Yeah, they can do that because people improve, so in theory, you could go from being reduced light, maybe just came out of a back surgery, although I can't imagine someone going from a back surgery to heavy, but, there's a variety. But they're not, the new application is a whole new application. Nobody's bound by what the old one is. Just, so it is going to be totally new. A heavy RFC is pretty significant. That almost suggests that you don't have any physical problems, lifting, walking, standing. So I don't know, the DDS isn't following, they're working only on the new time frame. So maybe your evidence now is shabby. I don't know. Have you been going? Have you been following up with whatever doctors were treating you for something so significant that you had reduced light on your prior RFC by the judge. Very fact specific, of course, GC, but you know, your current evidence is what they have to rely on, because you were already found not disabled before. That stuff wasn't good enough. You know, it wasn't disabling enough. You have to have better evidence now, and or if you changed age categories, that can have a big difference on whether you get awarded this time. And if you, the age category, if you change, and also if your prior relevant work was a hindrance, if you were found that you could do your prior relevant work, now you can't because there's no longer PRW, because now we went from the 15-year rule that you had before to the 5-year rule of now. That can make a huge difference too. But above all, you just need to go and treat for those problems that you say keep you out of work. You cannot rely on the old evidence, because the old evidence depicted an able person with impairments, but you know, able to do some sort of work out there. So, okay. All righty. You're welcome, JR. Melanie, yay. Dad, good to see you. Oh, she's giving JR, she's giving you a little bit of her understanding of what can help the gout. Yeah. Very nice, Deb. This is Chandra, right, Chandra? Does SSI take back child support when approved from your check? Oh, gotcha. SSI, no, because SSI is it's like the poverty level amount that the government recognizes a person can't go under and generally be able to survive. It doesn't pay enough for your children. It only pays you for you. So they don't take back child support for that. If it was SSD, Social Security Disability, and you had arrears and like a court-ordered child support, then they could take that from your back benefits to pay it. And going forward. But SSI, no, because that is like the bottom net for one person. They can't be taking it for the children. It's never owed to, a person who has prevailed. It's never due to a person where for the kids. It's for that person alone. Kids can have other benefits that are much easier for kids to get when they're poor. They don't have to be disabled. They're going to get, probably SNAP and housing assistance and maybe even cash assistance for their custodial parent, But yeah, so don't worry about SSI and the taking of back child support or alimony. But with SSD, both may be possible. Okay. Christina, nice to see you from California. How you doing? How you doing, lady? Rum ham. Does high blood pressure count towards a physical ailment? It does. It can be a severe, an impairment for sure. And then whether it's severe or not would be another story. Because remember, once they find an impairment, they have to determine whether it's severe or non-severe. And a lot of times, whether or not it's severe or non-severe, if it's not limiting your work ability, then it's not going to really matter. But it's going to be in there. Sometimes people who are filing and, explain, well, you have to prove you can't do sedentary jobs as well as maybe the heavy jobs you used to do. And they're like, but I have high blood pressure. It's an impairment. I'm like, I know it's an impairment. Guess what? Most people who sit at a desk have high blood pressure. Case in point, and are treated for it. So unfortunately, that's not disabling from all jobs. Now you can have, if you have uncontrolled high blood pressure, ham, that can be a different story. So it really is fact specific. Like an uncontrolled blood pressure, they might be like, yeah, he's definitely limited to sedentary work. And then if you're in the grid area of which even being able to do sedentary work, which someone could do with most high blood pressure, you could still prevail on disability because of the grid rule that applies if you meet all the other criteria and all the other evidence rules needed for that. So it's always going to be an impairment. Whether or not it affects your case is a different story, right? The 6'8" Aquarius. Cool. Hello, and hello to you, 6 foot. If an SSDI appeal decision comes back in 4 weeks versus the regular 6 to 8 weeks, could that be a favorable decision? You mean like an appeal from initial to recon, 6 foot? First of all, it's not even regularly 6 to 8 weeks. Nowadays, ask anyone here, right, guys? Some of you have been waiting a year, 8 months. Coming back quickly. I have seen some of the quicker ones on recon come back quick because the person's evidence has not changed. I mean, they might have gone to their PCP again, and it's the same thing. Oh, he's got high blood pressure, and there's not anything of substance changing, and they quickly make they pretty much affirm the denial. So I don't think faster is better. It means that there might not have been a lot for them to review to make a decision to change their mind. But then again, every case is different, right? Don't I always say that? All right. Oh, Deb Lindley. Hi, Steph. I sure hope you and your mom had a wonderful time. We're there now. And nice travel weather, and your sister is doing well. Everyone is doing well. And we are in Michigan City, Indiana, Deb. And it's a beautiful lake. It looks like the ocean. And I'm being a Jersey girl. I used to like to see the ocean. Didn't get to go to it too much because I was northwest New Jersey. But I always think it's beautiful. And when I look, so I can look across the street over the houses in front of us and see the water line. And it's like blue-green. It's really pretty. It looks like the ocean, even though it's a lake. It's really cool. We have pretty much overcast weather, so we're not doing a huge amount of, well, we only got here yesterday, but, and I'm just doing work here and then spending time, You're welcome, Chandra. Lana, nice to see you. Lana Shegrud. Am I saying that right? If Social Security tells you you don't need a physical, is that a bad sign? I'm still waiting for my decision. That's a loaded question, Lana. I tend to find that when they don't need a physical, it's usually a good sign. Because sometimes I feel like in order to justify a denial, if you have weak evidence, they will give a CE and then deny you anyway, because a CE kind of confirms that, there's something you could do in their mind, in the maybe the examiner's mind. But when they say you don't need one, I often find that to be, and this is not going to be 100%, but I find that's because they have enough to award on the physical. So, or if there's mental involved, like a reduced concentration, even something kind of minor, but it's definitively there and they can see it, sometimes the physical is enough to, with that, particularly if your grids would probably be most applicable here, give an award. So fingers crossed for you, Lana, that is what's happening here. GC, what happens if a person on SSI does 9-month work program and get the quarters back for SSDI? I'm not sure what you mean by what happens, but because it seems like you're throwing in a bunch of numbers here that might be referring to various aspects. So 9 months, are you working SGA? Are you working over TWP? Are you asking about the trial work period? I mean, if you were doing 9 months over SGA and you weren't in a trial work period, you're probably going to get discontinued. But you're talking now also about getting quarters back for SSDI. Working, and when he's talking about quarters, guys, I think GC, you're talking about earnings credits. It used to be called quarterly earnings credits. Now I think they're just called earnings credits because you don't have to earn them in each of the 4 quarters. You can get all 4 quarters. You can pretty much earn it in 1 quarter if you want it. That's where seasonal work can really be great if you don't want to spread out your work and just do. But yeah, so you can, it doesn't, regardless of what the other part is about your 9-month question, earning credits will help your date last insured DLI keep, if you're filing. This isn't, you don't have to do this if you've already won. But if you said on SSI though. Wait a minute, did you mean SSI or SSDI? Because again, everything's different there. But you still earn quarterly credits or earnings credits when you're on SSI and working very part-time to keep your SSI. Because remember, SSI has the income and resource limitations that SSD does not have. SSDs are different. So I'm not sure what your question is, but I love to see an SSI person move from SSI to SSD. Yeah, it's just, to me, it's great because then they get Medicare and then they don't have to have a dollar for dollar offset of the work they are earning. They get to keep a lot more of their money, you know, so it's good. And they can get off of the welfare SSI and get onto their own, what they already earned. JR. All right. Talking to Deb. 6-foot Aquarius. Appeal for SSD. Let me go back up. If SSD appeal, no, I know. I knew what you meant about appealing for SSDI, but there's various places of appeal. You have an initial. If you get denied, you can appeal for recon. On recon, if you get denied again, you can appeal to ALJ to get an ALJ hearing. If you get denied on ALJ, you can appeal to the Appeals Council. And if you get denied at the Appeals Council, you can appeal to Federal District Court. So various appeals there. I think you're probably talking about the early ones, initial and recon. That's what we're usually talking about, if not otherwise stated. Just me. Can old evidence in an old case be used in a new case if it relates to a new diagnosis? And would SSA be able to potentially reopen an old case? Potentially, yes. Reopens are not hard, they're not terribly uncommon, but they're not very common either. There are time frames also. There's a POMS on that someplace. SSI versus SSD, when you can reopen an old decision. If it's an ALJ decision, I think it's a bit harder. If it's not an ALJ decision, and if you can argue, you could show, I have evidence now from back when. You guys didn't have it back when. You didn't use it in my determination where you denied me. Judge or whoever, can you please reopen that and now include this because it might have changed the result. You can do that. You can also, it's a funny thing about old evidence. When I see good old evidence from someone's denied claim and now I'm taking them, you know, now I'm their attorney and I want to take, you know, we're taking a new claim. Sometimes I want that old evidence because I want to put it in to show the progression of how everything's gone on. To show this is not some new thing, you know, they've been suffering a long time. They weren't found disabled then, but they were a different age, you know, all that stuff was different. And not only does it show like a historical perspective, but I feel like, and you're saying here, it relates to a new diagnosis. If you were like complaining about a problem and it wasn't really being diagnosed, and then suddenly now it is, that is could be a whole new game changer for the new case because they can't find an MDI, medically determinable impairment, if you have not been properly diagnosed with it yet. I was talking about this not that long ago. A client of mine who, I hate when doctors do this, but they were saying suspected lupus for years, like 3 at least, treating her with lupus medication. Everything was lupus, full health medication, but it still said suspected. The ALJ couldn't accept it. Now, eventually, it did say it's been confirmed. Oh, gee, because someone decided to write it's confirmed. But that date ended up becoming the date of the new award because now there was this diagnosis. And that doesn't seem very fair, but sometimes you take what you can get. And this was a younger individual, and so you want to take what you can get because if we didn't win this time for this person, then there would never be Social Security disability. It would be SSI only. And then her Social Security retirement, of course, would have, not be as robust as you would have hoped. So using the old stuff it can be good in a variety of ways, particularly the pertinent stuff. I wouldn't just like blanket throw it all at them, upload. I would cherry pick. Since it's not technically in the relevant time period, I believe you can cherry pick. Just like, here's a report from, the post-surgical thing a year later where they're talking about how severe the pain is still, and it also explains the surgery. So now things like that can be helpful. Again, they're not the bread and butter because it's got to be current evidence, but it's relevant to showing the progression and those prior complaints that might be newly diagnosed now, and that can be a huge difference too. And you can always ask for a reopen. Don't always expect it, but if the goods are there, I would do it every time. Dimple, since I am waiting to apply, still working, not fired. Oh, Dimple, I know you're trying to hold out. When I apply, can I mention that I feel that I may meet a listing for autoimmune, skeletal, severe OA, or would my doctor? Your doctor's not going to fight your case for you, and he's not going to be researching listings and the, you know, in my estimation, he probably won't do that. The SSA automatically looks for listings. That's one of the steps they have to go through. So you can mention it. You know, you could say it in your remarks at the end. I think I may meet listing number blah 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 blah. It's not going to make it happen, but you can do that. That's fine. I mean, they should be looking at it whenever they see a diagnosis that happens to be, if severe enough and meeting the criteria, a listing, they're going to be looking into that listing. And you'll see that, by the way, if you guys ever get a handle on your DDE, disability determination explanation, it tells you what listings they considered and usually rejected. Since you're looking up the DDE, it's usually because you didn't win your case. Trial work program, GC. Okay, the trial work program, it's trial work period, by the way, not trial work program. And that is, the period starts the very first month you make over the trial work period amount, which is lower than the SGA amount. And you get up to 9 months. They can be non-consecutive as long as they all exist within a 5-year moving period. Then you will have used up your 9 trial work period months. The benefit of a trial work period, while it still exists before you scroll yourself out of it by working higher, more than 9 months, is that they can't look at the work you're doing to decide that you are not disabled. They can do it all the rest of the time. So as soon as you pop out of that trial work period, they can look at what you're doing and say, she might not be disabled. Look what she can do. Okay. You know, if you're going to be safe, just stay under it. That's the safest if you're going to work at all, which I think is great when people work. I mean, we usually talk about SGA, but the trial work period has some relevance too. Quite a bit, actually. Let's see, Deb. You're welcome, Dimple. Okay. All right. How are we doing, guys? Anybody have any more questions? Anybody? Okay. I'll be back in the regular office next Friday. But I will be checking in, of course, and videos, 9 o'clock a.m. video tips will be coming out. The regular time, 9 o'clock, you know, in the mornings. And then next Wednesday, I will be here, 1 o'clock Eastern Standard Time. Right now, I'm an hour behind that because I'm in India now. But, you know, we'll be back to the regular schedule going forward. You'll still see all the regular stuff coming out. You know, I'm still working. I'm still working here. I'm just doing it in the presence of other people that I don't get to see very often. And then, you know, my mom going on her trip to my sister's. So anywho, have a great weekend, guys. I hope you all have a safe rest of your weekend. Oh, we got a late arriver here. Nope, not Deb, just a thinker. 60, bone on bone knees, heavy work, 100-pound work, come home, can't do anything, but if not working, can do late stuff at home. Yeah, but remember, late stuff full-time, late stuff not full-time. Just a thinker, if you don't have representation, call me, and I can go over all the things that you need to be looking for. So much is going to depend on your treatment, so you have the right evidence to get the rules that you want applied to you applied. Okay? If you look in this will be on a replay. I did post the email and the phone number at someone's request, so you can reach out to me. Again, you're generally going to be told to, if it's about getting representation, please fill out the eval form on the website at joydisability.com. Upper left-hand link is for the free SSD eval, and we will look at it. You know, probably, you know, usually within a day to 3. There are sometimes exceptions, but like when I'm traveling or whatever, the ones that have to go through me. But if you do that, that is the way you get rather somewhat immediate attention, at least you know. Okay? Thank you, Deb. I know. It's Good Friday. Yeah. Hopefully it'll be a good weekend, and then there'll be Easter on Sunday. I should be getting back to Perry County, Pennsylvania on Sunday if I can do the whole ride, like 10 hours straight or so, 9 hours maybe. I'm going to try. I didn't do it the way here because I didn't think I could drive that long, but in hindsight, I might have been able to. It's the beginning part that's harder, and then you kind of get a second wind. So we'll see how I do. I'm no spring chicken anymore. Lana asks, how often should your attorney be in contact with you? If there's nothing to share to you, I don't know why that he would have to at all. If you ask him a question, I would like to think that they respond every time you ask a question. You know, if you're asking for just a quick question, you know, help with something, I would expect that. I would think one should be able to expect a response within a day or two. It might be if you're asking like, hey, can you teach me how to do SSD? And he says, no, that's different. But a response nonetheless. It could be, no, we don't do that. You know, we just handle your case. You know, you can go take the classes like we did, blah, blah. We're not here to provide treatises or education, you know, seminars, but at least a response. You know, I think having a portal really helps. It helps me tremendously. It's amazing. I mean, I can, and my wonderful help can respond to things at any time. You know, if I don't get in till 10, I could still, you know, I could be winding down, and I could still sometimes, you know, if I'm not, you know, going to bed, I can respond to sometimes, you know, just because it's a quick question. Let me just get it to them. In the morning, they'll have their answer. It's so good. I don't know why everybody doesn't have it. Of course, I'm a little anal about all this, right? Dimple, Dayton area. I don't know. I did go all the way through Ohio. That's Ohio, right? I was 80. All 80. Made it kind of easy. Marnie Peterson. Hi, Marnie. 54, major depression, anxiety, plus musculoskeletal. I'm sorry, Marnie. Similar to the suspected example. Wasn't, oh, God, that suspected diagnosis, right? Wasn't included. Initial app has become chronic. Attorney had me only brief answers on my recon. It's going to be the recon. Just remember, too, guys, you don't have the recon and the initial. The main things are getting all of the doctors that you're robustly treating with and have been in the immediate past and will be in the future. That's what that's about. The recon, the appeal itself is not the battle. You're not forging arguments. You are giving information so they can go get those records, you know, to defend your case. So I wouldn't worry too much. Your attorney probably knows exactly what he's doing, or she. It's not leaving out any medical providers. For me, I ask my people to, when we have a spot in the portal in their file where they can go to every time they go to a doctor appointment, and they say who, when, and for what. And as long as we already have that doctor's information because they gave it in the application, or we have a subsequent, you know, when you're not doing application material, it's like a reusable page to put new doctors and shoot them right up. And so during initial and recon, it's a steady process of keeping the SSA apprised, sometimes ordering records, asking the SSA to order records, what have you. So I'm sure he knows what he's doing. You know, he has every incentive to win for you. So I'm sorry you had to go to recon, but maybe now it'll be different if there's an actual legitimate diagnosis that they delayed on, which is infuriating. It's a real problem. I can't believe doctors don't get sued more than they do for poor record keeping and not being diligent. Okay. Trish, you're welcome. You have a great weekend. Oh, Dimple, I'm way north of Dayton. Okay. Yeah, I can't type either half the time, Dimple. No worries. Asleep at the wheel on 80? Yeah, you know, Deb. I had my mother was in the car with me, and I had like old classic rock and pop on from like the 70s. I was bellowing because it's the only way to stay awake. I had some podcasts on initially, but it was a little sedate. So then I had all these Great old tunes. And I sing really loud in the car, and I have listen to my voice. I have a horrible singing voice. So I was just trying to make my mom, make her laugh. But anyway, that's how I made it through all those hours, and the hours just kind of flew. So anywho, guys, all right. So we've been here about an hour. I think we're good, right? I will be here next Wednesday, guys. That's our normal day. Wednesday, 1:00 p.m. Eastern Standard Time. And any more questions, you know where to find me. And you can also just ask questions like with response to a video, one of the dailies that come out at 9:00 if you can or want to. And I will either sometimes quickly answer right on there, or I will do a video on it. Okay. So any which way, good to see you all, and have a great one. I will see you then. Bye.